number 54, the people of the state of New York versus Carlos Galindo. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court. Eric Washer for the Office of the Queens County District Attorney, Melinda Katz. Can I reserve 2 minutes of rebuttal time, please?
You may, sir.
When the appellate term dismissed defendants' convictions of 2 traffic infractions on speedy trial grounds, it relied on a statutory provision that took effect 6 years after the defendant's arrest and nearly 4 years after his trial. The Court concluded that the extensive amendments to the criminal procedure law that took effect in January 2020 had brought traffic infractions within the ambit of the 3030 statute. But that conclusion was wrong. Section 3031E did no such thing. But even if it had done what the appellate term thought it did, that Court's conclusions that the Pepper factors mandated applying that statute retroactively were mistaken, since the result in this case was that a statutory provision that was supposedly new was applied to proceedings that had concluded years earlier. There are really 2 issues in this case, and the first one is, what did Section 3031E do, if anything? And 2, if it brought traffic infractions within the ambit of 3030, then should it be applied retroactively?
Well, before you get to that, counsel, I'm on the screen. I'm wondering why it's so necessary to do that in the order that you're going to describe. I'm concerned about the retroactivity. I'm not sure that we need to concern ourselves with retroactivity. If the court were to conclude, contrary to your argument, that 3031E was intended for, on its face, to mean that traffic infractions are offenses for purposes of 3030, and if the court concludes that's exactly what the statute meant before, why do we need to really do any retroactivity analysis?
Well, Your Honor,
don't we come out in the same place if we decide that the statutes pre-amendment and post-amendment, that statute covers traffic infractions, as offenses for purposes of the statute?
Well, Your Honor, I don't think the Court can affirm on that basis, because that really wasn't preserved below. The argument that's being advanced here is that when traffic infractions are charged along with a greater offense that's subject to 3030, then in that case, but not when they're charged standing alone, but in that case, that they should be dismissed. But when the greater charge has exceeded its speedy trial time. But that really wasn't litigated below, and it really should have been, because at the time, the appellate term's cases were completely to the contrary. So that really wasn't brought to the attention of the criminal court.
Well, but what's litigated is whether or not the motion to dismiss the indictment also includes these traffic infractions, so the analysis is whether or not the statute applies. My question was only if the court, I'm not saying we would, I'm just saying if the court were to decide that the pre- and post-amendment versions of the statute function exactly the same, we don't have to do a retroactivity analysis, we can just figure out whether or not indeed they are, as the appellate term concluded, a statutory mandate that if the misdemeanors, right, if the people exceeded the time for the prosecution of this criminal action, because you exceeded the time on the misdemeanors, the traffic infractions also have to go because the entire instrument goes.
Well, you wouldn't do a retroactivity analysis if you found that previously, pre-January 1st, 2020, that this law included traffic infractions. But of course, I think this is a much easier case for us based on the language at the time. Traffic offenses were not mentioned at all at that point. So 1E does mention traffic offenses for the first time, but previously it didn't. So,
but traffic infractions have always been offenses. I mean, that has not changed.
They've always been offenses, but pre-January 2020, there was no mention of them in the 3030 statute. Therefore,
but why would you need to if they're offenses? If they're already within the category, why would you need to?
Because you can't dismiss a count on speedy trial grounds unless there's a speedy trial time period associated with it. And
well, this is what, okay, I want to ask you about this because I found this very confusing in the briefing, as I understand the statute, the instrument is what's dismissed. It's not count by count because you're looking at the top grade, right?
No.
So if you had up to 6 months, right, because there's a felony,
No.
you had after 6 months and the court concludes it's exceeded beyond the 6 months, it's not like the misdemeanors can stay, correct?
No, well, no, the misdemeanors can't stay because they have their own speedy trial time. So if you've exceeded 6 months, you've exceeded 90 days or 60 days. But I don't agree that the statute mandates dismissal of the entire accusatory instrument.
Okay, so let me just understand the way this is very helpful to me, the way you view the statute to work, that if you've got the felony and let's just say a felony and a misdemeanor, and the time for the misdemeanor is exceeded, then you can make a motion at that point, right? You don't have to wait the full 6 months on the felony. You can just wait for the time period, which is, of course, less time, on the misdemeanor and make that motion for just the misdemeanor. Am I understanding you correctly?
I think, yes, but I think as a practical matter, you wouldn't do it because you would then one of the exceptions to the speedy trial time would kick in, and you would stop the clock as to the felony. So I don't think as a practical matter, people would do that, but yes, I think.
So then how can it possibly function the way you say? I mean, the statute is intended to avoid the delay by prosecutors, which is to the benefit, obviously, of the defendant. So how can it possibly function the way you argue as opposed to the way they argue, which is you count from the highest grade?
Counsel, can I interrupt
Yeah.
here for a second? I have a question.
Yeah.
It seems to me that the way the statute works, it inflates the lesser crime to the higher statute of limitations. So if you have a misdemeanor and a felony, you get the 6 months. For the felony, when you make a motion under 3030, you refer to 170 or the other procedural vehicle, you dismiss the instrument in that case because the lower statute has necessarily been subsumed, right?
Yes.
So if you've blown by the 6 months speedy trial time, you've blown by the 30 days for the misdemeanor, right?
Yes.
So it elevates that statute, the 3030 time, for the lower crime. My understanding is for traffic infraction then and now, there is no speedy trial clock.
Yes. So that, yeah.
So when the motion gets made under 170, let's say, and it's tied to a misdemeanor, you dismiss the misdemeanor, but there's still no speedy trial clock for the traffic infraction.
Yes, and that's exactly our point. So notwithstanding the fact that traffic infractions have always been offenses, the appellate terms has always held that.
They just never had a speedy trial clock.
Correct.
And they still don't.
And they still don't. So as to your point, it doesn't make sense to say that traffic infractions are subsumed within the speedy trial analysis for the greater offense because they don't have a speedy trial time
Now,
assigned.
let me ask you this. If you had a misdemeanor DWI and you just charge it in an information and you go by whatever the clock is for that under speedy trial, let's say it's 3 months, whatever, and it gets dismissed, can you bring a traffic infraction based on the same facts and circumstances that underlie the misdemeanor count?
If it hadn't been charged initially in the information?
No, like you charged it in the information, but you lost it on speedy trial grounds as a misdemeanor. Can you charge a traffic infraction based on the same conduct?
Well, if it's in the same accusatory instrument, that we could proceed as to the infraction.
No, but let's say you just never charged it as a traffic infraction.
I'm not sure that you could in a misdemeanor. I think there are felony scenarios when there's been a dismissal on speedy trial grounds where you could bring another accusatory instrument, but I'm not sure that you could do it in your situation. I see my light's almost on, but I do want to address retroactivity. I think that there are a few procedural rules that are more ill-suited to retroactivity and retroactive application than speedy trial provisions, because essentially when you have a new speedy trial provision for a class of offenses that never existed, basically what's going to happen is that as the effective date comes, then you're going to have dismissals of any cases that don't meet the speedy trial requirements that never existed. So when you think about retroactivity and reliance interests, and it just doesn't make any sense to do what the appellate term held here. And I think that there's really no legislative history that would suggest that that's what the legislature intended. It's an irrational result. That there was, of course, there was an 8-month delay here.
What's the test that's applied? Is it Pepper or something else?
It's not Pepper because 1E is a statutory amendment. So we're looking at the rules of statutory interpretation. We're trying to determine what the legislature intended. Pepper is a set of rules that this court uses when it's trying to determine whether its own new rules apply retroactively. But that's a very different analysis than trying to discern what the legislature has done here. And I think there's essentially agreement between myself and my adversary that the legislative history here is not clear. And you would expect that when a new speedy trial provision was going to apply retroactively, if that's what the legislature intended, and we don't think that it is, that there would be very clear legislative history and a statement of legislative intent.
Thank you, counsel. Counsel?
Good afternoon. May it please the court. Hannah Gladstein for the defendant respondent, Mr. Galindo. The plain language of CPL 3030, then and now, designates one time limitation for one criminal action.
But
That is-
I have trouble understanding that because 3030 doesn't provide anything in way of procedure for dismissing. It just says the motion under a different statute should be granted. But in example 17025, I think it is, for informations and complaints, that provides for dismissal of individual counts. So in the ordinary time, if you don't have a traffic infraction, if you blow by the higher speedy trial time, by necessity, everything else is gone. So you do dismiss the instrument. But where you have a traffic infraction, it's viable because there is no time limit on it. It's not, to me, it seems that the traffic infraction gets a shorter time limit because it's married with more serious charges. It still doesn't have any time limit.
Well, as to the idea that we can make count-by-count motions to dismiss based on 17035, it's our position that that's a statute of very general applicability that governs motions to dismiss for a host of grounds,
Right.
many of which you would want to go count by count. Facial sufficiency of a misdemeanor accusatory instrument. However, that general statute, which is external to 3030, cannot sort of overwrite the internal logic
But
of
then why did they
3030.
refer to it? They could have just said shall be dismissed. They referred to the mechanism in the other statute.
I think that there are timing procedures in the other the other statute just sort of authorizes the motions. I think that 3030 contains its own language designating specific time limitations attached to a criminal action as a whole and applicable to all of the offenses therein. The people's construction of 3030, where even if an offense is joined in an action with other offenses that are subject to a time limitation, that simply because there's no, they're grafting in this requirement that's not there in the statute, that it only applies to the
Well,
types of
aren't you
offenses.
doing the same thing, counsel? Because you keep saying treat it as a whole, but the statute itself treats it separately depending on whether it's a felony, a misdemeanor, or a violation. So the statute is not treating it as a whole. The statute, as Judge Garcia says, references 17030, which specifically talks about individual charges. So aren't you really making the same assumption just the other way? Can't we at least say that perhaps it's ambiguous?
Well, I think that where we all agree is that traffic infractions are offenses. And when you look at the language of the statute, it says a criminal action must be dismissed within, let's say, 90 days for an
But it doesn't say
misdemeanor.
that. It doesn't say that. It says a motion shall be granted, right?
It says a motion to dismiss must be granted.
Right.
When they're
Under
not ready.
statute 17030, which
Right.
provides for count by count.
Well, so as to the question that was posed before about whether then the defense could just file serial motions at 30 days, 60 days, 90 days, the people say that practically that's not going to happen, but it might. Like, let's say, for example, that a defendant who has a long history of convictions for 220.03, the Class A misdemeanor of drug possession, picks up another one of those cases, but also is charged in the same accusatory instrument with the B misdemeanor of sex abuse 3, which carries tremendous consequences, SORA registration, that person will have a real interest in getting rid of that B misdemeanor at the earliest possible time. So there are these instances where a person will file that motion at 60
But I think
days,
you would
and then there will be
lose, I
another
think you
one.
would lose that motion all the time under the statute, because the lower statute for the lesser crime, although it may have different consequences, but as defined here, the lesser crime is elevated, it's inflated to the greater. So if you marry that misdemeanor with a felony, you get 6 months before you can make your motion under 3030, right?
Well, I think that there is a sort of practical sense in which that is what ends up happening, but that's because they are joined in the criminal action, and it's not because 17030 authorizes count-by-count treatment of the accusatory instrument. I mean, if that's where we end up, then I think we do wind up in this universe where you can...
One of the purposes, though, of 3030 seems to me, yes, it sets the time limits, and the people have to be ready, and that burden is on them, but because the different counts may have different time limits, instead of doing this, where, okay, you're not ready in 3 months on the misdemeanor, we're going to move to dismiss, and then 2 months, we're going to move to dismiss on the lesser misdemeanor, it gives the people then 6 months to be ready on anything that had a lesser 3030 time. So you can't make a motion against the misdemeanor under 3030 because that statute, that time, that 3030 time, has been inflated to 6 months.
Well, what the statute says is that they have 6 months to be ready on the criminal action and the offenses joined therein.
I don't think it says that.
Well, counsel, let me ask you this while you're looking at that, because I cannot read it as clearly perhaps, and I may be missing your conversation and your colloquy with Judge Garcia. It does seem to me that each one is exclusive, because A applies if there's a felony, B applies if there is not a felony. So no, you can only look at A if you've got something that has a felony. It's not that one is subsumed in the other. Each of them applies to a different kind of criminal action, and D applies when nothing is a crime. So I'm having difficulty, and perhaps when you're answering Judge Garcia, you can address that also.
D applies when one is a violation, I thought, but my point is just that you need to have the two, but where you have the two, where you have a misdemeanor and a felony, you elevate the misdemeanor's speedy trial time to 6 months because you don't want these motions saying you're not ready on the misdemeanor, dismiss that, but you still have 6 months on the felony.
I disagree that that's how this statute reads. It's 90 days for the action. It does not provide for separate clocks.
But it doesn't say action, right?
90 days.
It does say action. It says criminal action,
Yes.
and B does say not a crime.
It
It
says,
says 90 days from the commencement of the criminal action, but it's not tied to what the charges are there.
well, I would then go back to this court's decision in People v. Cooper, which analyzed, in that instance, the question was, what was the effect of the reduction from an A to a B? And the court was very clear in that case that there is one clock for one criminal action that begins on the date of commencement, and that date of commencement only changes under the very narrow circumstances delineated in what was then 3030 sub 5, it is now 3030 sub 7. So Cooper actually does hold that it does go by the action. There, the reduction from an A to a B, this court held, didn't change the complexion of the case because it was not one of the 3030 sub 5 circumstances. So the court was very clear that there's one clock for the action. So Cooper, I think, is instructive in this case. I do want to address preservation and reviewability since the people did raise that. This court, well, the issue was preserved in the criminal court by Mr. Galindo's motion, which sought dismissal of the entire accusatory instrument, and the motion court expressly ruled that 3030 did not apply to traffic infractions. And then because of the posture in which this case reaches this court, 470-35-2A squarely puts this case within this court's purview. This is a question of law decided adversely to Mr. Galindo in the criminal court. He was the appellant below, and he is the respondent here. This court could reach this issue even if the appellate term had not touched it at all. And under 470-35-2A, this court can affirm the decision of the appellate term while substituting its own reason, which is what we would propose because we agree with the appellate term in its construction of 3030 and how it treats traffic infractions when joined with misdemeanors. However, where we part company with the appellate term is its holding that 1E somehow worked a change in the statute. It's our position that that's how it always was. This court does not even need to reach the retroactivity issue.
Well,
but
counsel, how could it be how it always was? Because is the placement significant? Putting 1E, that language now under 3030, and using the language that's specifically the antithesis of Gonzalez certainly indicates some legislative intent. Do you agree?
Well, yes, I think that 1E was pretty clearly intended to abrogate Gonzalez. It's very directly responsive to this idea that the legislature, had they not intended traffic infractions to be covered, would have used the term petty offenses, which is a position that the people don't even adopt. They disclaimed that in their leave letter to this court. So what they were, the addition of 1E left A through D entirely untouched. And 1E was simply meant to clarify that when a traffic infraction is one of the offenses joined in a criminal action that is governed by A through D, it must also be dismissed.
But
So-
counsel, if the statute, let's just assume, meant what the appellate terms had interpreted it to mean before the amendment, right? Let's assume that it did, just for now. How did 1E change the meaning?
Well, I'm not sure I'm following.
Because let's assume the appellate terms were right. They were interpreting it correctly, that the traffic infractions didn't get dismissed the way this was written. How does 1E change that?
Well, I think that there is no, I think that if this court is going to abide by the maxim of statutory interpretation that instructs this court to give meaning to a legislative enactment and not assume superfluity, then we really have to read it as an abnegation of Gonzalez and that line of cases. Otherwise...
And I understand that would be kind of the purpose of what they were doing. But as a practical matter, in terms of changing the mechanics of the statute, how would it affect the analysis?
In what sense?
Because they were always offenses, so if before, then the appellate term was right, assume, and that it didn't apply to traffic infractions as written, how does the change in 1E change the mechanics of that analysis? Other than, I understand your point, the intent of the legislature was to change it, I accept that position for this purpose, but what changed mechanically?
Well, if you assume, it's kind of a paradoxical question, or maybe I'm not understanding it, but if you assume that the appellate terms were correct before, then what you're assuming is that the legislature intended, it should have used the term petty offense, which 1E is
Well, there's a
very
lot of ways
clearly-
they could have done it, you know, to make it clear, but they chose this, and I'm just saying, put aside their intent, if I just look at that language and offenses always meant traffic infractions, what practical effect would that have on the operation of the statute?
Well, if traffic infractions always meant offenses, then what that means is that when you reach the time limitation for a criminal action, that a traffic infraction is joined in, then it would be dismissed along with the rest of the offenses. I see that my time is up.
Thank you, counsel. Counsel, your rebuttal?
I just want to quickly address the last point that Judge Garcia was asking about. You know, if the legislature had intended to abrogate this long line of appellate term decisions, it didn't do the one thing that it needed to do, which was to assign a speedy trial time to traffic infractions. That which was the basis for the appellate term's decisions for all of those years. It wasn't that traffic infractions weren't offenses. Of course they were. They always have been. That's clear. But the appellate term's basis for excluding them from 3030 was that they didn't have a speedy trial time. So therefore, you cannot dismiss them simply because a greater offense has exceeded its speedy trial time. There was also some conversations about 17031E that really does control here. That allows for the dismissal of the entire accusatory instrument or any count thereof. That's, of course, referenced in 3030 subdivision E. And so that's what happens in these cases, and that's the other statute that the appellate terms relied on when they found that you could have an offense, a misdemeanor being dismissed on speedy trial grounds, but the traffic infraction would still remain. Lastly, I do think that we have to...
Counsel, can you address that? I'm sorry, I'm on the screen. Address the argument regarding sort of the generalness of those two cross-references, and because the title of both is a motion to dismiss, and it's sort of the entire accusatory instrument. It's not to dismiss counts. It's in the description, absolutely, that it does say the instrument or any count thereof. And defense counsel argues that's because some of them, of course, make sense. One could do it by count, but given the structure of 3030, which is the specific statute, it could not be by count. It has to be by dismissal of the entire instrument. Why is she wrong about that?
I think she's wrong about that because it makes sense in this specific circumstance. Traffic infractions do not have a speedy trial time. So therefore, in the specific case where you have any other offense that is covered by subdivisions 1A through D, then those counts are subject to dismissal on 3030 grounds, but the traffic infraction is not. So it makes sense that 17031E allows for, in some cases, the dismissal of the entire accusatory instrument, and in some cases, some of the counts, but not all of the counts, particularly traffic infractions, because they're not governed.
But let me ask you this. I mean, look, a traffic infraction is civil, correct?
Yes, it's not a crime, right?
Okay, yeah, so it's not a crime. It may be included in these instruments with these other crimes, with the crimes, or with a violation that says none of which is a crime, that's letter D.
Right.
So it certainly makes sense, given that it's not criminal, not the seriousness of it, that you're not necessarily finding a reason to include a time, because the time is only relevant really if you're going to have just two infractions. Otherwise, the other times would fit, right? Because they're each exclusive to one another. That's my point. A is if you have a felony.
Right.
B applies if there is no felony, right? So, I mean, that's the way that works. They're exclusive to one another. They're cabined.
Right. But
So the entire instrument falls because you're always looking to the highest grade.
well, right, and that certainly is ordinarily the case, but it couldn't be the case when you have something like a traffic infraction that has no speedy trial limitation to it. And you know, there's
Well, that's what I'm saying. I'm not sure I understand that, because the point is the criminal action fails.
well, no,
So
but
this is an offense that's part and parcel of the highest grade.
well, no, well, on that, you know, I disagree, going back to 17031E, that you don't have to dismiss the entire accusatory instrument. And I think, you know, the argument here is really premised on the idea that it was sort of irrational for the legislature to exclude traffic infractions because they're just another kind of petty offense. But it's not inconceivable that the legislature made a choice not to include them because they're not crimes. They don't have some of the characteristics that animate speedy trial statutes to begin with. Most people will get charged with a traffic infraction at some point. It's not the sort of thing that hangs over your head and, you know, doesn't
Right,
allow
so
you
then I agree with you. It's very logical on its own that the legislature might, given all that the legislature has to consider, that might not be something that troubles them because it's not a crime. It's a civil offense, and it doesn't have the stigma attached to it I assume there are people who get traffic infractions, many people. So, but the others, yes, there would be a stigma attached to it, and they are a criminal other than that letter D that says nothing is a crime. So in that sense, it's, right, if all you have are traffic infractions, you can see why it wouldn't be covered. But there does seem to be logic to the legislature determining that it gives a max amount of time based on the highest grade for the prosecution to declare readiness. We all understand that it actually may exceed this time because you might deduct periods of some delay that should not fall on the shoulders of the prosecutor at all. So it should not undermine their prosecutorial and investigatory process. But if indeed you've got the highest grade and you've exceeded the time for the highest grade, then everything falls, and something that's civil should not be able to continue. Doesn't that make sense? I mean, there's a logic to that, is there not?
There's a logic to that, but respectfully, I think there's a logic for excluding them as well for the reasons that I've stated, that they don't
But
simply...
I thought that your first argument was that the legislature intended to do that, but failed to do it in the way they wrote the legislation.
Well, I think that there's two possible explanations for 1E. One is that the legislature tried to do this, but they didn't do the thing that they needed to do to accomplish it. Now, there's also some...
And that's the first argument you made.
That is, but we've also included some materials in the appendix which show that there were drafts of this legislation that were circulated through the Codes Committee that did make traffic infractions part of 1D. But they didn't end up in the legislation ultimately, and that might be an indication that the legislature thought about this and ultimately abandoned the idea. And 1E was something
that depends on, I think, the conclusion that the legislature took the trouble of enacting an amendment that had no effect.
Well, no, I'm not sure that would necessarily be correct. This was obviously negotiated through the budget process. It was a huge piece of legislation. So 1E could have been something that was left in inadvertently. That's also a possible explanation, because it really has no effect. It's a redundancy that didn't cure the problem that the defense suggests that it intended to cure.
Thank you, counsel.
Thank you, Your Honor.